When we talk about the Section 42 notice, that's the formal notice that's served on the freeholder and sometimes on other parties to notify them that you are claiming a lease extension under the statutory route. So the statutory lease extension is the entitlement to 90 additional years added to the existing lease length, and to reduce the ground rent, remove it entirely and replace it with a nominal peppercorn payment. Now, the service of the notice is usually the most contested part of the process, simply because it can be in the interest of the freeholder to push back the valuation date, which is set when the Section 42 notice is adequately served and can be evidenced. So it's important to, one, serve the freeholder at their correct address, and for this purpose it's usually best to serve at the address which is on the most recent service charge or ground rent demand, and to avoid common mistakes such as serving on a land registry freehold title address, which can sometimes be 20 or 30 years out of date. And unfortunately, there's no obligation on a freeholder to keep that address at the land registry up to date, and I've certainly been involved in court cases where a judge has looked at it and said that's not good service. So really the best way to proceed is to get your most recent demand from the landlord and look at the part which says formal address for notices, and to serve your Section 42 there. That will fix the valuation date, it avoids questions as to invalid notices or invalid service, and it will get you off on the right foot.